If you've got a specific legal question or situation you'd like to see covered here, drop it in the comments, because that's genuinely where a lot of future topics come from. I read them, and some of the most useful specific videos on this channel started as exactly that kind of comment from someone dealing with a real situation, so don't hesitate. Whatever it is, I'd like to hear it. All right, let's keep moving. You're recording. Phone up, camera on, finger steady, and you're capturing every second of a police encounter happening right in front of you, on a public sidewalk, at a traffic stop, outside a courthouse, wherever it is. And for a moment, it feels like exactly the right move, because you've heard, correctly, that you have the right to record police in public. You've heard it enough times that it started to feel like settled, simple, obvious law. And it largely is. But here's the thing that almost nobody tells you. The thing that sits just underneath that general right, like a trapdoor that opens the moment you step on it, without knowing it's there. There is one specific thing people do while recording police that quietly strips away every single legal protection they thought they had. One action that transforms a completely lawful, constitutionally protected activity into something that can get them arrested, charged, and prosecuted, and it's not what most people would guess. That's what this entire video is about. Not just the right to record, which is real and worth understanding clearly, but the specific thing that ends that right, the line that's easier to cross than you think, what happens on both sides of it legally, and exactly how to make sure you never accidentally hand away a protection that belongs to you by doing one thing you didn't even realize was a problem. Before we get into it, if you want to actually understand your rights instead of operating on half-remembered rumors and guesses every time a situation unfolds in real life, subscribe right now, because this is exactly the kind of thing this channel exists to walk through completely. And quick note before we start, this is legal education and general commentary, not legal advice for your specific situation, and some details shift state to state, but the core principles and the core mistake we're covering today hold up across virtually everywhere in this country. Let's get into it. Let's start with the foundation, because this is one of those topics where the foundation matters more than people expect, and getting it slightly wrong at the beginning leads to getting everything else slightly wrong too. The right to record police performing their duties in public spaces is protected by the First Amendment. That's not a rumor, that's not a technicality someone found buried in a footnote somewhere, and it's not something courts have been ambiguous about. Federal circuit courts across the country have consistently held that recording police in the course of their public duties is a form of protected expression and news gathering under the First Amendment. The logic is actually fairly simple once you hear it stated directly. Police are public officials carrying out public functions in public spaces, using public authority. The accountability that comes from being observed and documented is not a burden imposed on them. It's a feature of how public accountability in a democratic society is supposed to work. The courts have said as much, repeatedly and in increasingly clear terms over the past couple of decades, as the smartphone made every person with a phone a potential documentarian of encounters that might otherwise happen with no record at all. It's interesting, honestly, how often variations of this general subject keep coming up, across completely different specific situations, over and over. I think that's because the underlying pattern is more universal than people initially assume. A moment of pressure, a question that sounds simple but carries real legal weight, an instinct to just go along with things smoothly rather than pause and think it through. That basic shape shows up across an enormous range of otherwise completely different situations, which is exactly why understanding the underlying pattern, rather than just memorizing one specific scenario, ends up being so useful. Once you see the shape clearly in one context, you start recognizing it everywhere else too. All right, let's dig into today's specific version of that pattern. So the right is real. It exists. You can hold your phone up on a public sidewalk and record an officer making an arrest, conducting a traffic stop, giving someone instructions, or just walking through a public space on duty, and doing so is protected activity, even if the officer doesn't like it, even if they tell you to stop, and even if it makes the entire encounter more complicated for everyone involved. The discomfort of being filmed does not override the right to film. But here is where we slow all the way down, because this is the exact point where most of the videos on this topic stop, shake your hand, and send you out the door with confidence that's only partially warranted. The right exists, yes, but the right is not unlimited, not unconditional, and not self-executing in the sense that simply holding a camera makes everything you do from that point forward automatically protected. The protection attaches to specific conduct, in specific circumstances, in specific ways, and there is one mistake, one particular action, that courts, prosecutors, and officers themselves have identified repeatedly as the thing that breaks the protection and hands the legal upper hand entirely to the other side. That mistake is interference. Let me say that again, slowly, because the word sounds simple, and the actual content of it is more nuanced than the word itself suggests. The one thing you must never do while recording police, the one action that converts a protected constitutional activity into an arrestable offense, is to physically interfere with what officers are doing. And the reason this sounds simple but isn't, is that interference, in legal practice, covers a much wider range of conduct than most people assume when they first hear the word. Let's walk through what interference actually means, because this is the heart of the entire video, and it deserves real care. In the most obvious version, interference means physically inserting yourself into an active law enforcement situation, walking up to officers mid-arrest and putting your hands on someone, moving between an officer and a person they're trying to detain, grabbing someone's arm or blocking an officer's path in a way that directly prevents them from completing an enforcement action. That version most people understand. You cannot physically obstruct a police officer performing a lawful duty, camera in hand or not, and claiming you were just trying to get a better angle doesn't transform obstruction into journalism. The camera is not a magic wand that makes everything you do with it constitutionally protected. If the conduct itself would be illegal without a camera, the camera doesn't make it legal. But here is where it gets genuinely complicated, and where a lot of people who would never dream of physically grabbing an officer still end up crossing the line. Interference in the legal sense can also include things that look, from the outside, like nothing more than assertive recording. Let's walk through each of them specifically. The first is standing too close. Courts and law enforcement have consistently recognized that officers have a legitimate interest in controlling the immediate scene of an active enforcement situation, for reasons that are not always obvious to someone watching from the outside. An arrest can turn physical. Weapons can be present. A person being detained can make a sudden move. Evidence can be at risk. These are not hypothetical scenarios invented to justify keeping cameras away. They're real operational realities, and an observer standing 18 inches from an active arrest, camera rolling, is a physical presence in a space where things can go wrong fast, regardless of that person's intentions. Courts that have upheld the right to record have also consistently recognized a corresponding right for officers to direct observers to move back, to record from a safe distance, to stay outside an active scene's immediate perimeter. Refusing to comply with a clear, lawful directive to step back is not an exercise of your recording rights. It is interference with a police function, and it can result in arrest, full stop, regardless of the camera running throughout. The second is verbal interference, and this one surprises people more than almost anything else in this area of law. You are recording a stop. An officer is speaking with someone. You begin narrating loudly over the interaction, making comments, asking the person being stopped questions, calling out what the officer is doing in real time, in a way that's clearly meant to be heard by and directed at both the officer and the subject. This is not just recording. This is active participation in a law enforcement encounter, and the line between observation and participation is one that matters legally, even if it doesn't feel like it in the moment. Loudly talking to the person being questioned, giving them advice in real time, telling them what to say or not say, making statements clearly designed to influence the encounter as it unfolds, rather than simply document it. All of that can cross into interference, and it does so regardless of the recording happening simultaneously. The third is disobeying a lawful order to disperse or relocate. If a lawful order goes out for people to clear an area, to move back, to disperse entirely, and you remain because you're recording, you are not exempt from that order by virtue of the camera. Press credentials exist partly for this reason, and even credentialed press in some circumstances are subject to specific zone restrictions during active law enforcement operations. An ordinary person with a personal phone is not above a lawful dispersal or relocation order, and treating the camera as a shield against compliance is a mistake that ends, predictably, in arrest for failure to comply, not in a constitutional victory for press freedom. The fourth is getting in the way of emergency operations specifically, because there's a version of this that involves not just police but also paramedics, firefighters, and emergency medical personnel. If someone is being rendered emergency aid and you position yourself in the space where that aid is being administered in a way that physically impairs access or movement, the camera makes that situation no better. The recording right applies to police performing their duties in public. It does not apply as an override to every other possible competing interest in every possible emergency scenario. So what does all of this add up to, practically, for someone who genuinely wants to exercise their recording rights correctly, who wants to hold that camera up and create that record without accidentally stepping into any of these traps? Let's walk through exactly that, because this is where the video pays off practically. The single most important thing to understand is distance. Specifically, meaningful physical distance between yourself and whatever is actively happening. This is the variable that controls more of your legal exposure than almost anything else, because it addresses the interference question before it even becomes a question. If you are far enough away that your presence doesn't physically affect the space where officers are working, it becomes dramatically harder to characterize your recording as interference with anything. How far is far enough? There's no universal precise number, because it depends on the scene, the space, how many people are present, what's actively happening. But the working principle is this: if an officer asked you to step back, would it be possible to read that request as physically reasonable given what's happening, or would stepping back require moving to a location where recording would be practically impossible? If a reasonable person looking at the scene could see why your position creates operational concerns, you're probably too close. If you're on a public sidewalk across the street from a traffic stop with a clear line of sight and a phone camera with any zoom capability at all, you're almost certainly in a position that doesn't raise interference concerns. The second thing is silence, or at least the discipline to stay out of the encounter verbally. Record. Document. Let the camera do exactly what cameras do, but do not narrate directly at the officer in a way that constitutes participation. Do not give the person being stopped real-time legal advice through your running commentary. Do not make statements designed to influence the encounter, rather than simply capture it. The distinction between documenting and directing is real, it matters legally, and maintaining it is entirely within your control. You can speak, you can say your name to the camera if you want to establish your presence on the record. You can say where you are and what you're observing. What you cannot do, without risking the protection you're there to exercise, is make yourself an active participant in what's unfolding in front of the camera. The third thing is compliance with directives that aren't asking you to stop recording entirely. There's an important distinction here that trips people up, because it feels counterintuitive. If an officer says, "Stop filming," that is an order that, in most jurisdictions and most circumstances, you are not required to comply with, because the order itself is likely unlawful, and numerous courts have made clear that officers cannot simply order people to stop recording as a matter of course. But if an officer says, "Step back, move to the sidewalk, please clear this area," those are directives about your physical position, not about your camera. And complying with them while keeping the camera running accomplishes two things simultaneously. It removes any interference question from the table, and it demonstrates, on camera, that you were cooperative, that you moved when asked, that you stayed outside the active area, and that at no point did you create a physical obstacle to what the officers were doing. That's an extremely strong record to have, if anything about the encounter ends up being challenged later. Let's talk about why that record matters. Because the reason people record police in the first place is documentation, accountability, evidence, the ability to say afterward, "Here is exactly what happened." Not a memory, not an account, a recording. And maintaining that purpose requires that the recording itself be untainted by conduct that could undermine the recorder's credibility or legal standing. Here's the problem that interference creates. Beyond the immediate risk of arrest, if you are arrested or charged in connection with a recording incident, the recording you made becomes evidence in your case, rather than someone else's. Suddenly, the accountability document you created to protect someone else is being used to examine your own conduct. And if that recording shows you moving closer despite being asked to step back, if it captures you speaking loudly into an active encounter, if it shows you refusing to comply with a positioning directive while continuing to film, then the very tool you thought was protecting you has become the best evidence against you. That's the full inversion of what recording is supposed to accomplish, and it happens specifically when the one thing covered in this video gets crossed. Let's talk about what police can and cannot lawfully do in response to recording, because this matters for understanding where your protections actually are. Police cannot lawfully order you to stop recording simply because they prefer not to be recorded. That's settled law in most jurisdictions, backed by multiple federal circuit decisions, and the fact that officers sometimes give that order anyway doesn't make the order lawful. It just means you're facing a situation where a lawful right is being violated, which is itself a serious matter, but a separate one from whether you're doing anything wrong. If an officer says, "Stop filming me right now," the correct response is to keep recording and to say calmly, clearly, "I have the right to record police in public," and to keep the camera running. You don't have to shout it, you don't have to turn it into a confrontation, but you don't comply with an unlawful order to cease a constitutionally protected activity. Police cannot lawfully seize your phone simply because you used it to record them, without specific legal justification. If an officer takes your phone, demands you hand it over, or attempts to delete recordings from it, those actions raise serious Fourth Amendment concerns of their own, and the courts that have looked at this have generally been quite clear that the existence of a recording on your phone does not, without more, justify a seizure, and certainly doesn't justify on-the-spot deletion of that content. If your phone is seized, do not consent to a search of it, do not provide your passcode voluntarily, and connect with an attorney as soon as possible to address the return of the device and the preservation of the content on it. The recording you made has evidentiary value that lasts only as long as the content remains intact. Police cannot lawfully arrest you for recording in a public space where you have a legal right to be, as long as your recording doesn't cross into the interference territory we've been walking through. The arrest, if it happens under those specific circumstances where you've done nothing wrong, is itself potentially a violation of your First and Fourth Amendment rights, and that's the kind of thing that can and does result in civil liability and, in some cases, significant settlements or judgments against the departments involved. But you fight that battle afterward, not in the moment of the arrest itself. The moment of the arrest is not the venue for winning this argument. You comply. You document everything you can. You say clearly that you do not consent to anything. You invoke your right to remain silent and your right to an attorney. And you have the actual fight in the actual venue designed for it, which is not a street corner. Let's talk about the specific laws that can be used against recorders who cross the interference line, because knowing what's on the other side of that line makes understanding why it matters much more concrete. Obstruction of justice, or obstruction of a law enforcement officer, is one of the most commonly deployed charges in situations where recording crosses into interference. These statutes exist in essentially every state and at the federal level, and they vary in their specifics, but they broadly cover conduct that hinders, delays, obstructs, or impedes an officer in the performance of their official duties. Critically, these statutes in most jurisdictions do not require that the obstruction be successful. An attempt to obstruct, an act that creates a risk of obstruction, can be enough to support the charge even if the officer ultimately completed their task without significant difficulty. This means stepping into a space, reaching towards someone being detained, making physical contact with anything or anyone in the enforcement scene. All of that can constitute obstruction regardless of the outcome of the underlying enforcement action. Disorderly conduct is another frequent charge in recording-related arrests, particularly when the recorder has been vocally involved in the encounter rather than silently documenting it. Disorderly conduct statutes are famously broad in most places, and they cover things like unreasonable noise, conduct that disturbs the peace, behavior that creates a public disturbance, all of which are categories that can be applied to a recorder who's turned their documentation into participation by narrating loudly, directing others in the scene, or creating a commotion around an active enforcement action. The breadth of disorderly conduct laws is exactly what makes the verbal interference point so important. You don't have to physically touch anything to end up on the wrong side of a charge under one of these statutes. Failure to obey a lawful order is a charge that flows directly from the directional compliance point covered earlier. When an officer gives a lawful order to move back and a recorder refuses because they're recording, the charge that follows isn't about the recording, it's about the failure to obey the order. The recording is irrelevant to that charge. What matters is that a directive was given, it was lawful in its nature, and it wasn't followed. Courts examining these cases look at whether the order itself was lawful, not at whether the person receiving it was holding a camera. A recording does not transform an unlawful failure to comply into protected activity. Resisting arrest is a charge that can stack on top of any of the above if the actual moment of arrest involves any physical resistance, even passive resistance, which in some jurisdictions includes going limp, bracing against being handcuffed, or any other physical conduct that makes the mechanics of arrest more difficult for the officers involved. If you are being arrested, even if the arrest itself is wrongful, physical resistance is almost never strategically sound, because it adds charges and complicates the picture dramatically, even when the underlying arrest is ultimately dismissed or found unlawful. The clean approach is always to comply with the physical mechanics of arrest, state clearly that you do not consent and that you believe the arrest is unlawful, and take that fight to court with counsel. Let's talk about something that comes up constantly in conversations about recording police and deserves a careful treatment, which is the distinction between recording in public and recording in semi-public or private spaces, because the same right doesn't extend the same way across all of those contexts. In a genuinely public space, a sidewalk, a public park, a public street, a plaza, anywhere that members of the general public have unrestricted access as a matter of public right, recording police is protected by the First Amendment principles we've been walking through. The space being public means you have a right to be there, and if you have a right to be somewhere, you generally have a right to record what you observe from there. But spaces that feel public but aren't quite are worth thinking about more carefully. A shopping mall is a common example. It feels like a public space. It often functions like one, but it's actually private property, and the owner of that private property can impose conditions on who's there and what they do there, including conditions about recording, subject to some limits. If you're recording in a mall, a privately owned plaza, a parking lot that's technically private property, the public space recording protections are not as clean and complete as they are on a genuine public sidewalk, and whether officers can ask you to stop may depend as much on the property owner's permissions and rules as on the constitutional principles that govern purely public spaces. Government buildings and their immediate surroundings occupy yet another space in this analysis. Courthouses, police stations, city hall buildings, all of these involve layers of security and access control that interact with recording rights in ways that don't apply on a simple public street. Some government buildings permit recording in publicly accessible areas. Some have explicit policies against it. Some distinguish between interior and exterior spaces. The rules are not uniform. They're not always posted. And finding out in the moment that you've crossed a line in that particular building's recording policy is not an outcome worth risking. If you're planning to document something at or near a government building specifically, understanding the policies of that building in advance is worth the time. Let's talk about the specific scenario of a traffic stop, because this is probably the single most common context in which people encounter police in a situation that feels recordable, and it has its own practical wrinkles worth walking through. If you are a passenger in a vehicle that's been pulled over and you want to record, you are generally within your rights to do so. You're in the vehicle, which is on a public roadway, and you're recording police performing a public duty. The camera can roll. The specific thing to be careful about in this context is not drawing additional focus to yourself in a way that transforms your presence from passenger with phone to active participant in the stop. Recording quietly, without narrating loudly, without directing comments at the officer beyond what's needed for the direct interaction, is the approach that keeps you on the protected side of the line we've been discussing. If you are a bystander, observing a traffic stop from outside the vehicle, all of the distance and non-interference principles apply directly. Stay on the public sidewalk or shoulder, stay far enough back that your presence doesn't affect the operational space of the stop, keep the camera running, and let the documentation do what documentation does. If you are the driver being stopped and you want to record the stop yourself, you can. Your phone mounted and recording, your dash cam running, both are legitimate. What becomes complicated is when recording the stop becomes the primary focus of the interaction, to the point where it affects your ability to comply with the officer's basic instructions during the stop itself, because failure to comply with those basic instructions introduces a different set of problems independent of the recording. The camera can run. Your hands still need to do what they need to do in a traffic stop. Those two things are not in conflict if you plan for them not to be. Let's talk about what happens specifically when an officer tries to take your phone, because this scenario is jarring when it happens, and people rarely know instinctively how to respond in a way that protects them. If an officer demands your phone or attempts to take it, the first and most important thing to understand is that you should not physically resist having it taken. This is the same principle that applies everywhere else in encounters with police. The moment it becomes physical, you've created a much more complicated situation that includes potential charges having nothing to do with the recording rights question, and none of those charges help you. So if the phone is being taken, let it be taken while clearly and calmly saying, "I don't consent to a search of my phone." Those words matter because they preserve the Fourth Amendment challenge to any search of the content that might follow. Once the phone is taken without a warrant, you have a Fourth Amendment argument about the seizure itself. Once any content is searched on the phone without a warrant, you have a Fourth Amendment argument about the search. Once any content is deleted, you have additional arguments about evidence tampering and destruction of evidence that are legally serious in their own right. All of those arguments belong in court, with an attorney, not in the physical confrontation at the moment the phone is being taken. Write down everything you can remember as soon as possible afterward. Everything. Because your memory of exactly what was said, exactly what happened, the sequence of events, the officer's badge number or name if you could see it, the time, the location, all of that becomes part of the evidentiary picture that matters when the legal fight happens in the right setting. Let's talk about the audio component of recording specifically, because there's a significant legal wrinkle here that applies in some states and genuinely changes the analysis in ways people need to understand before they find themselves on the wrong side of it. In what are often called two-party consent or all-party consent states, recording audio conversations requires the consent of all parties to the conversation, not just the person holding the recorder. These states, and there are a meaningful number of them, have wiretapping and eavesdropping statutes that apply to recorded audio, and recording audio without the other party's consent can itself be a criminal offense under those statutes, even in a public space, even when filming police, even when the visual component of the recording is entirely protected. This is critically important and underappreciated. The video may be protected, the audio recording of a conversation you're part of, or of a conversation between the officer and another person, may not be, depending on your state. Illinois was one of the most notorious examples of this issue for years, with an eavesdropping statute that was used to charge people who recorded police with audio, and while that specific statute was challenged and ultimately reformed, the underlying issue of state audio consent laws has not disappeared across the country. Before you record with audio in any state, understanding whether your state is a one-party or all-party consent jurisdiction is worth doing, because the difference between those two categories is the difference between a protected activity and a potential criminal charge for the audio component of your recording, separate from and in addition to any interference question. Let's talk about what a recording you've made can actually do for you, practically. Because part of understanding why not to lose the protection is understanding what the protection is worth when it's preserved correctly. A clean recording of a police encounter, made lawfully, from an appropriate distance, without interference, without verbal participation in the encounter itself, is one of the most powerful pieces of evidence available in any subsequent legal dispute about what happened. It removes ambiguity. It removes the credibility contest between your account and an officer's account. It removes questions about your memory, their memory, what time it was, how many people were present, exactly what was said and in what order. A clean recording is an objective contemporaneous record, and its value in any proceeding, whether that's a disciplinary complaint, a civil rights claim, a civil lawsuit, or a criminal defense, is genuinely difficult to overstate. A recording that was made while crossing the interference line is something entirely different. It's a recording that may be accompanied by your own arrest and prosecution, a recording that shows your conduct as part of the scene it was meant to document from outside, a recording that invites questions about your own behavior rather than focusing entirely on the encounter you were there to capture. That's not a powerful piece of evidence for you. That's a complicated exhibit in a case where you're now also a party, and the story it tells is no longer a clean one. The gap between those two outcomes is exactly the line this video has been walking through. Let's talk about circumstances that feel like they might justify crossing the line, because this is where a lot of the real-world difficulty lives. In the scenarios where what's happening in front of the camera is genuinely alarming, and the instinct to do more than document is completely understandable. You're recording a stop and something looks wrong. An officer's behavior looks excessive. Someone appears to be in pain or distress. Something is happening that looks, from where you're standing, like it shouldn't be happening. Everything in you wants to do more than hold up a camera, wants to say something, move closer, intervene somehow, make it stop. That impulse is a deeply human one, and recognizing it honestly is part of understanding why this particular line is both important and difficult to maintain. Here's what's actually true in those moments. The recording you're making, if you're making it correctly, from a distance, without interference, with clean audio capturing exactly what's happening, is the most powerful thing you can do for the person in that situation, in the moment it's happening, because it creates the evidence that everything that happens afterward will depend on. The intervention you're imagining, moving closer, saying something directly into the encounter, physically involving yourself, dramatically increases the risk that you end up arrested or charged, which means you are no longer a witness, you are no longer a documenter, you are now a defendant, and the recording you are making is now evidence in your case rather than accountability for theirs. The recording that could have changed everything gets tangled up in the situation it was supposed to document, and neither of you ends up better for it. This is genuinely hard. Watching something that looks wrong from a distance, keeping the camera steady, not moving, not shouting, not reaching, takes a specific kind of discipline that doesn't come naturally in a charged emotional situation. But understanding why that discipline is the right move, functionally and legally, is exactly what makes it possible to actually maintain it in those moments, rather than acting on an impulse that feels like help but ends up being the opposite. Let's talk about what to do immediately after any recording encounter wraps up, because the moments right after are almost as important as the moments during, and people consistently underestimate how much the post-encounter period matters. Back up the recording immediately, and I mean the moment the encounter ends, before anything else happens. Cloud backup, airdrop it to someone else, email it to yourself, whatever your fastest backup method is, use it. The reason for the urgency is that a phone can be lost, damaged, seized, or wiped between the end of the encounter and when you would otherwise think to deal with it, and a recording that no longer exists provides no accountability for anything. Backup comes first. Write down or record a voice memo of everything you remember about the encounter while it's fresh, all the details that might not be fully visible on the recording itself. The time it started, where exactly you were standing, any orders or directives you received, and what exactly was said, any identifying information you caught from badge numbers or vehicles, anything that was said to you directly, anything that was said that might not have been fully audible on the recording. Memory fades quickly and degrades in ways we don't always notice happening. A contemporaneous written or recorded account of your own observations is a supplement to the video record, not a replacement for it, and having both is significantly more valuable than having either one alone. If you were told to stop recording, if your phone was seized, if you were detained, questioned, or arrested in connection with the recording, connect with an attorney as soon as possible, because your rights in each of those scenarios are specific, and the timing of how you respond to the situation matters. An attorney who works in First Amendment or civil rights matters can assess whether the conduct you experienced was unlawful, whether you have a viable claim, and what the right steps are from where things stand right now. Let's talk about what to do with the recording once you have it backed up and documented, because this is actually a separate question from making the recording itself, and it's one that carries its own considerations worth thinking through in advance, rather than improvising after the fact. You can share it, you can post it, you can submit it to journalists, advocacy organizations, oversight bodies, or directly to the legal system if it becomes evidence in a proceeding. All of those are options, and the First Amendment that protects the making of the recording generally protects the sharing of it as well, as long as the content doesn't fall into narrow categories of unprotected speech that don't apply to authentic recordings of public encounters. What's worth thinking about before you share is the purpose you're sharing it for, what context you're providing, and whether the sharing itself could be mischaracterized. A raw recording shared with context about what it shows is a powerful accountability document. A recording shared with inflammatory framing designed to provoke a specific reaction, rather than inform about what actually happened, is something different, and the way the surrounding context frames what's in the recording matters for how it's received, interpreted, and used. The recording itself is the evidence. What you say around it when you share it is also something you're responsible for. Let's talk about one more thing specifically, and this is a scenario people don't usually think about until it's directly in front of them. What happens if you're the only witness, the only person recording, and law enforcement asks you to hand over the recording voluntarily as evidence of something they're investigating? You can say no. You can also say yes. Whether you should say yes depends on what's in the recording, what they're investigating, whether the recording actually shows what they're describing, whether handing it over serves the interest you were recording to serve in the first place, and whether consulting with an attorney before you make that decision is something the situation permits. Handing over your recording voluntarily is exactly that, voluntary, and voluntary means the decision is yours. If law enforcement wants your recording and you don't want to hand it over voluntarily, they would need a warrant or subpoena to compel it. Same as with any other private property or evidence. And your declining to hand it over voluntarily is not obstruction any more than declining to let an officer into your home without a warrant is obstruction. You are not required to be a volunteer in an investigation simply because you happen to be present with a camera. Let's bring all of this together, because I want to leave you with a clear, complete framework that sits in your mind without requiring you to reconstruct it from scratch under pressure. The right to record police in public is real, is constitutionally grounded, and is recognized by courts across this country. It protects you from being lawfully ordered to stop filming. It protects your recording from being lawfully seized without cause. It exists because public accountability for public officials performing public functions is a feature of how this society is supposed to work, not a bug to be patched. But that right has one condition attached to it that no other consideration can override, and that condition is non-interference. The moment your recording becomes interference, by moving too close, by participating verbally in the encounter you're documenting, by refusing lawful directives about your physical position, by physically inserting yourself into the scene, by disobeying dispersal or relocation orders, the constitutional protection you were relying on does not follow you across that line. It stays on the other side, and the recording you made, instead of being the accountability document you intended, becomes part of the case against you. The practical application of all of this is this: stand back, keep the camera rolling, stay out of it verbally, comply with positioning directives while the camera keeps running, and let the recording do the one thing a recording is uniquely able to do, which is to show, without ambiguity and without depending on anyone's credibility, exactly what happened. That's the whole job, that's the whole point. The discipline to stay out of the scene while documenting it is not a concession, it's what makes the documentation actually matter. Stay back, stay quiet, keep recording, and know exactly where the line is, because the protection you have is worth protecting. There are a few more situations connected to this that deserve careful attention, because the core principle we've covered applies across a wider range of encounters than just a straightforward public sidewalk recording, and each variation has enough of its own texture to be worth walking through specifically, rather than leaving you to work it out yourself in the moment it becomes real. Let's talk about recording inside a courtroom or courthouse, because people sometimes extend their understanding of the public recording right into spaces where it doesn't apply the same way, and courtrooms are among the clearest examples of that mismatch. Courtrooms are governed by the presiding judge's authority over proceedings in their courtroom, and that authority includes controlling what recording happens and under what conditions. Most courtrooms in most jurisdictions prohibit recording of active proceedings without specific permission, and that prohibition doesn't conflict with your First Amendment recording right as it applies in public spaces, because a courtroom during active proceedings is not the same kind of public space as a sidewalk or a public park. Judges have explicit authority over their proceedings, and violating a judge's order about recording in a courtroom is contempt of court, which is a serious matter entirely independent of anything else we've covered in this video. Courthouse hallways, public lobbies, and exterior spaces may be different in their rules than the courtroom itself, but when in doubt about any courthouse or government facility, find out the specific rules of that specific building before you assume public space recording principles apply uniformly. Let's talk about recording interactions between police and someone you know personally, because the emotional stakes in this version of the scenario are even higher than a stranger's encounter, and that's exactly why the discipline required is harder to maintain and more important to understand in advance. If a friend, family member, or someone else you know is being stopped, questioned, detained, or arrested, the impulse to get involved is much stronger than it is with a stranger. The instinct to say something directly to the officer, to call out to the person being detained, to move closer to make sure you can hear exactly what's being said, all of that is more intense when it's personal, and it's precisely when it's most intense that the interference line is easiest to cross. The recording you make of a loved one's encounter with police is potentially the most important evidence available for anything that might follow from that encounter, and protecting that recording by staying on the right side of the interference line is the most valuable thing you can do for that person, far more valuable than intervening directly in a way that gets you arrested and removes you from the situation entirely. The version of you who stays back, keeps the camera steady, and stays out of the encounter is the version of you that can actually help them afterward. The version of you who crosses the line is a defendant, not a witness, and that distinction matters enormously for what happens next. Let's talk about recording at protests and demonstrations specifically, because this context adds layers that aren't present in a simple one-on-one police encounter, and those layers change some of the practical considerations in ways worth understanding. At a protest or demonstration, recording police activity is common. There are often multiple people doing it simultaneously, and the general right to record public police conduct in a public space applies in full. But the specific situations that arise in protest contexts can complicate the application of that right in ways that deserve care. If police issue dispersal orders during a demonstration, a person continuing to record who is not dispersed when ordered to do so is in exactly the same position as anyone else who hasn't dispersed, subject to arrest for failure to comply, regardless of the camera. Journalists with press credentials sometimes have specific arrangements that apply during these situations in specific jurisdictions, but a private citizen with a personal phone doesn't carry those credentials, and the camera is not a pass-through for any other obligation that applies to everyone else present. If officers establish a perimeter, a buffer zone, or a designated press area during active enforcement operations at a protest, staying outside that perimeter while recording everything within view from outside it is the approach that keeps you legally clean. Crossing into an established perimeter to get a closer angle, while continuing to record, is exactly the kind of conduct that looks like interference and can be charged accordingly. Again, the camera doesn't change what the rest of your conduct looks like from a legal standpoint, and legal standpoints are what eventually matter. Let's talk about recording on private property that's open to the public, because this is a nuanced area that creates genuine confusion and worth spending time on. A store, a restaurant, a hotel lobby, a privately owned plaza that functions as a public gathering space. All of these are spaces where the public is generally welcomed and regularly present, but they're private property, and private property owners have the ability to set conditions on the use of their property that go beyond what the government can impose in a public space. This includes conditions about recording. A store owner can tell you to stop recording in their store, and if you don't comply, they can ask you to leave, and if you don't leave, you can be removed or charged with trespassing. None of that conflicts with your First Amendment recording right, because that right as it applies to police in public spaces doesn't override a private property owner's ability to control what happens on their property. If police are present on private property and you're on that same property as a lawful visitor, you can record, subject to the property owner's rules about recording on their property. If the property owner's rules would have you stop recording, that's a private condition, not a government restriction. The officer asking you to stop because you're on private property that has a no recording policy is a different situation than an officer asking you to stop on a public sidewalk purely because they don't want to be filmed. Let's talk about what happens when you capture something unexpected on a recording you were making, for another reason entirely, because this comes up more often than you might think. A dash cam captures an accident or an incident involving officers. A doorbell camera captures something happening in the street outside a home. A recording of. Before I let you go, I want to say one more time that understanding your rights clearly isn't a small thing, even when the specific topic feels minor on the surface. It's the difference between navigating a real situation with confidence and navigating it with anxiety and guesswork. And that difference matters more than people usually realize until they're actually standing inside a moment where it counts. Thanks for spending this time building that understanding with me today. I'll see you in the next one.